it's about equity, it's about roles and responsibilities, it's about transfer restrictions, it's about exit. But you need to have some of these fundamental points documented between the founders. Now, it does not matter whether the founders are friends, whether they're family, whether it's a combination of them. But the moment you have more than one founder, it always makes sense. And we would very much recommend for there to be some sort of a document which holds it all together. And like I said, it's important to ensure that that document is also enshrined in the charter documents of the company. We lawyers talk about called good leaver and bad leaver. What if a founder were to exit on good terms? What if a founder were to just pack up his or her bags and leave one fine day? These are all things which it's very important to be documented in an agreement. Like I said, it doesn't need to be 100 or a 200-page document. It can be a simple document at an early stage, but which sets the foundation for what you want to do later.
Hello, all. Welcome back to the AEIF Podcast. I am your host, Manu Kulkarni, and today we'll deal with the issue of what are the legal requirements to build a solid legal framework to help startups scale. And for this, we have an extremely talented specialist lawyer, Yashaswi Mohanram, with us, partner and head of Bangalore Touchstone Partners, a leading corporate law firm. Yashaswi and I are both alumni of Sainik School. Although we were there was only 1 year in which we overlapped. I have continued to be in touch and I have worked with him also. Yashaswi graduated from the National Law School of India, University, Bangalore in 2001. He is also a qualified company secretary and has completed a PGP in management from the Indian School of Business in Hyderabad. Prior to Touchstone Partners, Yashaswi had a small stint at Infosys and was also an associate at White & Case in Singapore. He represents multiple leading corporates in a variety of transactions and corporate related matters. Yashaswi, thank you so much for being here. It's truly a pleasure to have you with us today.
Thanks so much for the generous introduction. Real pleasure to be here and great to meet you again. And just at the outset, as dry as the topic may seem at first glance, hopefully both of us can make this an interesting session for our viewers. And since it is two lawyers speaking, probably we should start with putting out the cautionary caveat that what we discuss here does not constitute professional legal advice, and that founders and startups should consult with their own lawyers and not ChatGPT on any questions of law.
I think I'll come back to the last point towards the end on how disastrous it can be sometimes to listen to GPT. But having said that, the first question that I have for you is, aren't you yourself heading a startup?
That's a very interesting question, Manu. I suppose I should start off by saying that because one at least needs to be a late millennial, if not a Gen Z or a Gen Alpha, to qualify as a founder of a startup. And since, as you can imagine, I don't tick any of those boxes, it would probably disqualify me at the very threshold. But on a more serious note, I think, yeah, but there is a reason why law is a profession and not a business. I mean, as you will know very well, Manu, as a legal professional, one is expected to uphold the law and serve the interests of our clients. So while some of the principles applicable to a startup could well be adapted usefully by law firms, I'm not sure if it's really appropriate to equate a law firm with a startup or even other professional services firms for that matter. I mean, for starters, lawyers in India, as you know, cannot solicit clients. So the traditional roles of sales and marketing that usually apply to other businesses, it's not really relevant. And I'm sure we'll talk more about this as we go along. But most lawyers and law firms are invariably set up as sole practitioners or partnerships. So they don't really lend themselves to scale in the manner that other businesses which are set up as limited liability companies do. And as you know, the concept of limited liability is so fundamental to the corporate culture. And indeed, as it happens, even in the US, where there are far fewer restrictions on lawyers and law firms compared to what we lawyers have in India, getting big funding into law firms is always an issue. I mean, I was just reading today that Blackstone has, the private equity fund house, has invested in a legal and compliance startup called Norm AI, but the law firm which will be using the services of that startup, which is also called Norm, but Norm Law, that needs to be independently owned and not really owned by Blackstone because there are professional rules on what lawyers or non-lawyers can do. So non-lawyers are prevented from owning law firms. So short answer to your question, no, probably we don't qualify well to be a startup.
So the takeaway, I guess, is when it comes to professional services, perhaps it's a slightly different legal matrix. But then
That's,
what
yeah.
but then what in Indian law or what generally in the legal system is a startup? Is it defined somewhere?
Yeah, so I mean, we've thought about this quite a bit, right? Literally speaking, a startup could be any new venture, a corner store selling daily utilities to an early stage tech company in Koramangala. Um, all of these should qualify as a startup. But in business parlance, I think it's fair to say that one would expect a startup to have two critical components. One, I believe, would be innovation, and the second one, it would be scalability. I think unless a business has these two features at its core, it will be difficult to call a venture as a startup. But since we are talking law, and since we need to talk about what sort of recognition do startups enjoy, particularly in India, in some ways the government of India has made it easier to have by having a definition of what is a startup. So it's officially recognized, and registering as a startup provides a whole host of tangible and substantial benefits. But first up, in order to qualify as a startup according to the DPIIT's definition, um, you should have a turnover of less than 100 crores. So you should really be starting out. You should be working towards innovation or improvement of existing products, which is the innovation criteria that I mentioned. It should be a new entity, so it can't be a hive off or a restructured entity from a much bigger organization. And of course, it will be considered as a startup for 10 years from the date of its incorporation. So if you were to fulfill all of these, you get eligible to be registered as a startup. And once you register, there are a whole host of benefits which become available to startups. And just to go through a couple of them without meaning to dive into the detail, the first one is tax benefits, where for 3 out of the first 10 years, any profits, of course, it's debatable whether startups can indeed or do indeed have profits, but to the extent that they have profits, there's a 100% exemption on tax. Um, in terms of ESOPs, there are key benefits to registering as a startup because as a default matter, founders or promoters, so to say, which is a term peculiar to Indian law, they are not allowed to have ESOPs issued to themselves. But this restriction is not applicable to startups which are registered with the DPIIT. So this is quite important for founders and investors to structure vesting and retention mechanisms. Also, another very important benefit is that as a company goes towards listing, SEBI has recently allowed founders to retain ESOPs which have been granted to them by their companies 1 year prior to the IPO. And this is quite important because we used to see several founders and startups come up with all sorts of schemes and maneuvers to not qualify themselves as promoters so that they can enjoy the benefit of ESOPs. But now, thankfully, SEBI has clarified this, and that's a big benefit. There are also certain IP benefits. There are also certain self-certification benefits. So I think the key takeaway is that there is indeed a formal framework in India to recognize startups, and companies and founders should consider benefiting from these various exemptions and concessions by registering themselves as startups with the
As a start.
DPIA.
And is it a very complex process to get registered or? is it a breeze?
Relatively straightforward, Manu. Relatively straightforward. We have seen that I mean, there will be a bit of paperwork to go through with the government in order to confirm that you meet all those criteria. But it is relatively straightforward, and invariably most uh, founders would tend to register themselves as startups.
And professional services are available for somebody who wishes to take professional assistance to register, easily available.
Indeed. Yes. I mean, you'll have lawyers, and then you'll have a whole bunch of chartered accountants, company secretaries, tax advisors who are very important. And in certain cases, you could have many of these under one umbrella. But equally, for some of these, you may need to go to a specialist. For example, to advise on certain technical aspects of law, you'd be better served to go to a legal advisor as opposed to, say, a big four or a chartered accountancy firm. Whereas on the flip side, particularly in India, if there are tax questions, it is really the chartered accountants and the financial advisors who are much better placed to advise on those aspects.
So, in short, it's advantageous to register, it's somewhat easy to register, and professional assistance is reasonably easily available.
I would say so, man. That's absolutely right.
Excellent. So, that would be very encouraging for a startup to know.
Indeed. And in fact, there are benefits to being recognized as a startup. So this is very much recommended.
Excellent. Now, the next question that I had, and I may be a lawyer, but more really from a layperson's perspective, we've all heard of things like partnership, LLP, company, one person company. According to you, what would be the recommended method to set up an organization to start a venture?
Yeah. So since this is the cricket season, Manu, I'm tempted to provide a cricketing analogy here. I'm not sure who this statement first came from, but it is often attributed to W.G. Grace, that if you win the toss, you choose to bat 9 out of 10 times. And on the 10th occasion, you think a bit,
Still bet.
but you decide to bat first. So I
Yeah.
would say that in most cases, a startup would be well advised to set up as a private limited company. Like you said, professional services are a bit different, where they could incorporate as a LLP or a regular partnership, or even some of them could remain as sole proprietors. But just to go over a couple of these aspects, right? And we touched upon this briefly earlier in as to what the benefits are of registering as a private limited company. And one of the most crucial aspects, which sometimes, I mean, entrepreneurs, they obviously have a different outlook to life compared to you and I. But the concept of limited liabilities is very crucial to understand. In that, unlike with, say, a proprietorship or even a normal partnership, once you set up a company, your liability as far as a founder, founding shareholder, your liability vis-a-vis third parties, be it customers, be it banks, be it even your employees, in some ways your liability as an individual is limited to the extent of your shareholding in the company. And that's a very crucial point, which often goes unnoticed. So unless you as a founder or a promoter are going to give guarantees or personal security to secure, say, a loan or any third party obligations, you're really personally not on the hook as far as third parties are concerned, or even as far as your own employees are concerned. Of course, there's a moral responsibility as a founder, but this concept of limited liability is completely hardwired into this concept of a private limited company. That's the genesis of the term limited in there. But more importantly, a private limited company mirrors what would be the most preferred vehicle for startups across the world, right? In the US context, it could be an LLC, uh, and so on and so forth. But that is the most preferred vehicle for startups with growth and funding ambitions because it lends itself to scale. You can have different forms of share capital. You can have a governance framework. You can have a board framework. You can have transfer restrictions. So it lends itself very well. As compared to, say, a company, if you were to talk about a partnership, there,
Mhm.
generally speaking, the liability of the partners is on a joint and several basis. What does it mean? It means that each of the partners is liable himself or herself for all the liabilities of the firm. So a third party going after a partnership can go after one or any of the partners, and that's quite
It's quite
suboptimal
prevalent
if
also.
you're looking to scale. Sorry.
That's quite prevalent also that
It is
when
quite
somebody goes
prevalent, but
after a
more in the
partnership.
context of professional services firms and the like. There is this mid path, if you like, which is a limited liability partnership, which offers the flexibility of a partnership, but it combines it with limited liability protection. But again, this is better suited for professional services firms, like consultancy firms, like law firms, like accounting firms, where they retain their individual professional identity, but they limit their personal exposure. But again, it does not lend itself to scale. Um, you'll find it, you'll struggle to raise loans from banks. You will not have venture capital investors coming in to invest in LLPs. So the key takeaways when viewed across all these structures, from a scalability, from a fundraising perspective, from a limited liability perspective, it's really a private limited company which is the best suited for startups in general.
And would you also say that transfer of shares, shareholders coming in, going out, multiple rounds of issuing multiple rounds of investment, they are somewhat easier when it comes to a company rather than say a LLP or a partnership firm?
Most definitely. In fact, I would say that with an LLP, and even less so with a partnership firm, because you don't have a share, you need to really deal with transferring partnership interests. So there are necessary structural restrictions in terms of what you can do with that. While LLPs are very suited for, say, funds which seek to invest in startups, where they can have these limited partners and general partners. It's perfectly well suited for that sort of a context. But for a business itself, it wants to itself scale, nothing really to beat a private limited company. And of course, as you move closer towards a listing, you need to convert into a public limited company where you then no longer have restrictions in terms of the number of shareholders you can have, but it's really a limited company that is best suited for this.
So I'm assuming only a company can ultimately reach IPO, which is what is
Absolutely,
every
that's
startup
correct.
founder's
That is
dream.
correct. That is correct. I
Excellent.
mean, these days you have things like REITs and InvITs, but those are very specialized instruments in the context of real estate assets, in the context of infrastructure assets. So even we've seen that they go public as well. But in 99 out of 100 cases, it's a limited company which is going in for a public listing.
So let's assume now that a startup founder or founders decide to incorporate a private limited company. I have about two or three broad questions. How simple or complex is that process? Two, from a legal perspective, are there things that one should necessarily keep in mind? And three, are there things that one usually misses? From your long experience, you have seen that people miss, and you say, these are the four or five things, come what may, don't miss, and you will get your act together.
Indeed, Manu. So, and I'll divide this into two, right? There are several procedural requirements when you go to incorporate an entity, and there are a few substantive aspects. These procedural aspects, they're relatively straightforward. You need to submit a few forms, you need to have a few authorizations like a identification number and a digital signature certificate, but those are relatively, I would say, mundane, straightforward. I don't believe founders necessarily need to worry themselves with those sort of things, because that can be handled by whoever is the professional who is helping the founder with the entity. But I'll just touch upon the few substantive aspects where a founder does need to focus on before incorporating an entity. And the first one is really the question of where do you want to set up your entity, and that is at the root of the whole thing, right? We've seen several cases, and you know these examples like Make My Trip and Freshworks, which are headquartered abroad and also they have pursued a listing abroad. So if you look at them, they're listed on either NASDAQ or NYSE, even though a bulk of their or some of their businesses is originates in India,
Acha.
but the entity itself is registered abroad and it's also listed abroad. But we've also seen cases where entities which have originally registered abroad, the likes of PhonePe and Zepto, we've seen this recent trend, and you may have heard of this expression called reverse flip, where they are flipping back to India and moving their headquarters into India. And this is primarily a function of two aspects. One is the nature of the business, and the second is the depth of the capital markets in the jurisdiction that you're talking about. So if, I mean, we've had what our capital markets have really been in full swing. I mean, SEBI got set up in the early 90s. So we're really talking about a 30-year history.
That year.
So in the initial few years, clearly there was no depth in the capital markets, and therefore founders were rightly so wary of a setting up here and also b scaling their businesses here. But as time has gone on, and particularly in recent times, where the capital markets here, there's this tremendous depth. We are amongst the top performing capital markets by whichever indicators you want to go by. And that comes with the function of we being fourth or the third largest soon economy in the world, and so on and so forth. So so we're seeing this trend of companies now to the extent that they have businesses which are customer focused in India. We are seeing that they're choosing to either incorporate in India, or if they're incorporated abroad, they're choosing to move their headquarters to India, sometimes with several with a lot of tax outgo, and then list here. So, but as to where you incorporate, it's a very key question. And I would say that particularly for B2C companies, if you have a business which has a bulk of its customers in India, like much like the way like PhonePe and Zepto do, it's much more helpful to have your businesses incorporated here. But if you're talking about a B2B business which have most of your enterprise customers abroad, then there is still a fair bit of thinking to do as to where you'll want to locate yourself. And I'll just mention a couple of other things apart from the jurisdiction which founders need to focus on while incorporating an entity. One is about the name of the company and the brand name of the company. And often there's a question as to whether the company name and the brand name needs to be the same. Do they have to be different? And the answer to that question really is that they can be different. There's no reason for your brand name and your company name to be the same. In fact, if you look at many of the startups which have gone public recently, their names, for example, Grow, which went public recently, the corporate name is on the lines of uh, billion brains garages and things like that. And in fact, we had this recent example of Zomato, which was one of the few companies where both its brand name and the company name were the same. But because now Zomato wants to or has got into several other businesses other than food delivery, they have chosen to rename themselves, the corporate name, as Eternal. So Zomato is one of the brands, one of the
Yes.
businesses under Eternal. So you
Completely.
don't want one of your businesses or your company name to be limiting in a certain way. So having a different company name allows you the flexibility to branch out into different businesses. So that's another substantive aspect. And the third point I would add, Manu, is that, and this is often a point that founders and startups overlook, and we'll probably come to this in a bit more detail later on. But when doing the charter documents of the company, rather than treat it as boilerplate, you should ensure that if you, to the extent you have a shareholders agreement or a founders agreement, that all the terms of that agreement are incorporated in the articles of association of the company because it helps legal enforceability. You should also take care to see that the articles and the memorandum have enough flexibility for issuance of shares with different classes because that gives you more flexibility in terms of the kind of investors you're able to attract. And the rest of it is really fairly straightforward. But I think these two or three aspects founders would be well advised to bear in mind.
So I had one question here. Typically, it's more than one founder. Sometimes it is friends, sometimes it is family. Would you recommend that they enter into watertight agreements on day one? Or is it that after they gain some traction, they should enter into those agreements?
It's a great
And
question,
a
Manu, and we
related
often,
question,
yeah, yes,
and a related question, if I am doing a startup, say, with two of my friends, is it all right to have different stakes? That is, should we go 33.33%, or should we, or is it okay for one person to have 50 and the other two to have 25?
yeah. And we often face this, right? Because we advise clients both at an early stage, late stage. We advise investors. So we're on the other side where we look at companies which have already had some sort of a structure, an angel round, maybe a series A round before the later stage investors come in. And what we see is that there's often a misconception amongst founders and startups that they only need to worry about documenting anything amongst themselves when seeking external funding and not before that. And I would say that nothing could be further from the truth. And the reason for that is much like how you would have a branding agency or one of your consulting companies like a McKinsey or Bain. If you were to go to any of them, they will invariably say that as a company, you need to write down your core values and your mission statement because there is a real value in doing that because it focuses people's attention. It gets rid of a lot of ambiguity. Much the same way, it's very important for founders to it doesn't need to be a fancy documentation, but you need to get those few things, whether, I mean, and mainly it's about equity, it's about roles and responsibilities, it's about transfer restrictions, it's about exit. But you need to have some of these fundamental points documented between the founders. Now, it does not matter whether the founders are friends, whether they're family, whether it's a combination of them. But the moment you have more than one founder, it always makes sense. And we would very much recommend for there to be some sort of a document which holds it all together. And like I said, it's important to ensure that that document is also enshrined in the charter documents of the company. It just lends itself to a proper framework from which you have clarity on the roles that the various founders are playing, what sort of equity do they have, when if they were to exit too early, what do they take with them, what do they leave behind, and that's vital, I would say, and very important for that to also talk about things like who owns the IP. Ideally, the entire IP should be in the name of the company as opposed to in the individual names or any names of any of the founders. There are concepts which we lawyers talk about called good leaver and bad leaver. What if a founder were to exit on good terms? What if a founder were to just pack up his or her bags and leave one fine day? These are all things which it's very important to be documented in an agreement. Like I said, it doesn't need to be 100 or a 200-page document. It can be a simple document at an early stage, but which sets the foundation for what you want to do later.
Just on this point, since we operate in some sense in different fields, I have seen often, your role begins when a company wants to start up. My role begins when people start quarreling. And invariably, I have seen a lot of quarrels for want of clear documentation. I have
Indeed.
seen scenarios where there are friends who have started up, there are promises made on WhatsApp exchanges saying both of us
Yeah,
will have 50% each. And then half of the startup's wealth is ruined in courts because
indeed.
somebody wants to say, no, no, you did make this promise. Somebody says you didn't make this promise. So that was one part. I have a question from Sagar. He wants to know, especially at the beginning stage, how does one provision for ESOPs, because ESOPs are seen as an encouragement also. How does one work about installing a very fair and efficient ESOP mechanism?
Yeah, great question. And ESOPs is really the desirability of ESOPs could, I mean, you if you were to read the financial press, it could either the ESOPs could sometimes be in real huge demand as it is now, given the way the capital markets are. And at certain other stages, people could be less enthused about ESOPs because if there is no exit eventually, how do the ESOP holders really get the value? But at the core of it, I would still say that ESOPs still remain the best bet for employees to meaningfully participate in value creation by startup. What do I mean by that? um, if you're a startup, by definition, you're competing against much more well-established companies, big corporates, big tech. So you, you probably will not do not have the name or the caliber or the reputation to compete on those terms against the big players. But what you can offer is an environment which is high growth, probably high risk, but equally you need to reward them well. And unlikely that in the initial stages of a startup that a founder will be able to remunerate his employees too well. So the promise that you give them is, unlike with a much bigger organization, you have a stake in the entity itself, and that is what
Skin in the game,
ESOPs do.
basically.
You're in the
More
game.
people
You're
with
you're
skin in the game.
absolutely more people skin in the game, and they have real rewards. If you're in it together, and if you make a success of it, everyone benefits. Um, so what we see is that it's usually the case that in the initial stages of a startup, it's all a little informal. So you don't have a formal ESOP pool, even though you may have promised one or two employees saying that, oh, you will be granted some shares. But it's definitely helpful to think about an ESOP from as early a stage as possible. And the ESOP pool, if you like, can range anywhere from 5 to 15% or 20% at the very outer limit. But it's important that you at least set aside an ESOP pool. Um, and investors typically, when they come in, they would also want to see whether this sort of an ESOP pool has been created separately. And from a founder's perspective, it's always helpful if the shares to be issued on an ESOP exercise comes out as fresh issue of shares rather than the founder having to transfer shares, because that would end up diluting the founder a lot more. But I would definitely suggest that founders should start thinking about ESOPs
From day one,
at an
from
early
get go.
stage.
Now, how does one value a share in an ESOP? If it is, especially if
So
it's going to vest after a few years.
yes. So what you do is you have what is called as a vesting schedule. So when ESOPs are granted, it's very rare that all the all the shares, all the ESOPs get vested on a particular date. There's usually a vesting schedule where you could have, like, say, a uniform staggered ESOP mechanism, where you have, say, 25% of options vesting uh, every successive year, or you could back end a lot of it where you say that it progressively gets increasing number of ESOPs get vested. And all this is a means also to, of course, retain the employee, where you give the message that the longer that you stay on in the company, the more shares that you're entitled to. And what happens at the end of that vesting period is that the employee is entitled to get to exercise the ESOP and acquire shares in the company at a historical price. So the strike price for the ESOPs is set on day one. Whereas if the company is doing well and it adds value, 5 years down the line, the company could be valued at 10x, but you are still entitled to exercise your ESOPs at X, which was the time when you joined the company. There is, of course, a
Company
tax.
isn't doing well. What if
Well,
the
if the
company
company is
isn't doing
not
well?
if the company is not doing well, then typically speaking, the ESOPs, at least at that point in time, it does not have too much value. But you never know, right? I mean, the company could bounce back in the future. So it's a long term game, and it's not that you have to exercise it at that very stage. You've got a time frame within which you're entitled to exercise it, and there's usually a tax implication associated with it, in the sense that because you're benefiting from this whole thing, where if the company has gone up to 10x but you are entitled to exercise at X, then you actually need to pay a tax on the delta. But then again, there are benefits or exemptions which are available to startups. So which is one more reason why it's good to be recognized as a startup from even the employee's perspective. But usually the real value of any ESOP is at the time when there is eventually an exit. And the exit could be either in the form of a sale to a strategic party, or the exit could be, as we are seeing with many of these companies which are going public now, is in the form of an IPO, where the employees are able to either sell in the IPO or more likely sell in the open market once the company has listed. But we are also seeing a recent trend of certain platforms offering to buy ESOPs and shares held by employees even before a company goes public. I mean, I know there's a platform with one of my counterparts called Hissa, which has set up a platform to provide liquidity to ESOP holders. But there are all of these options, and there are also other alternatives which certain companies choose to do, where if you don't want a share-based scheme, you can simply mirror that by having a cashless ESOP. What does it mean? You don't really issue any shares to the employee, but you pay them relative to how the company's stock price is doing. But then that is not really tax efficient because the employee is paying tax as salary as opposed to as capital gains, which is much better from a capital gains perspective.
Yashaswi, from ESOPs, let's move to intellectual property. We just touched upon it, but what are your views on how a founder or how a set of founders should protect their intellectual property, including how they create intellectual property in the first place?
Yeah, so there is again a misconception amongst uh, several startups that
Mm-hmm.
intellectual property protection is only got to do with registering IP and not much else. There is indeed a lot more to it, especially for startups which have breakthrough technology, which have code which is vital to what they're doing. It's very important that founders and startups understand how to protect and how to register intellectual property to the extent registration benefits are available. And there are a few things here which one needs to bear in mind. One is the fact that, I mean, how is intellectual property created, right? Because it's while there is a company, the IP is really created by people in flesh and blood. Either it could be the founders, or it could be the employees, or it could be certain consultants, but they are the ones who are creating the IP. It's important that all these individuals who create the IP, that there are assignment arrangements in place where effectively the founders or the employees or the consultants assign whatever intellectual property they have in the work product that they create in favor of the company, so that everything rests with the company. Because otherwise you have a odd situation where there are people working on it, they're employed with the company, but there is some sort of an ambiguity as to who exactly owns it, whether it is the relevant individuals themselves or whether it is the organization. So it's important that there are intellectual property assignment agreements, and these could be either standalone agreements or it could be hardwired into the employment agreements themselves. The
So,
second is, yeah,
in short, you're saying whatever intellectual property is created, whether it is called patent, whether it is called copyright, whether it is called trademark, it should all ideally stand in the name of the company. Or even if it's
absolutely,
created by an
absolutely.
individual, it should get assigned to the company.
Indeed, indeed. In fact,
Yes.
very recently we were advising a US company which was
Mm-hmm.
buying an Indian AI solution, and one of the things that we noticed in the diligence was that there were no intellectual property assignment provisions at all, whether as part of their employment agreements or otherwise. So, and we had to post facto ensure that the company went back to not just their current employees, but also the past employees who had worked on the application to get them to sign up to intellectual property assignments. And some of this is difficult. I mean, in this case, the company didn't have too many former employees, but if they were to have hundreds or thousands, you'll not be able to go back to each of them and set it right. So that's one. The other point I would just mention, Manu, in the context of IP, is it's important how you deal with your source code, which underlies your applications, because often customers or lenders could ask for source code to be kept in escrow with them or with a third party, and these need to be dealt with carefully, because when you're dealing with an acquirer who wants to either acquire the whole company or just the product itself, some of these could serve as limiting factors. And the last thing I would say is, I mean, and apart from having to register IP, whether it is trademarks or copyrights or patents, it's important to register if registration is available. But it's also important for startups to ensure that there is a proper documentation maintained of all the product designs, code versions, contributors, key development milestones, because this sort of a documentation is particularly important to prove your IP ownership. And if there are disputes, you always have priority if you have if you have a well documented set of IP for your company.
When it comes to choosing brand names, I had a few thoughts. I want to know what you think. If I can illustrate it in three examples, a name like Google, which when it was founded was perhaps not in the dictionary, is perhaps the best way. Something coined, something altogether new. I would say
Yeah,
something like Apple is not so great. It's a fruit available in the shop, but you're making computers or electronic devices. But what I have seen over
right.
and over in courts where maximum litigation is found is when you choose brand names that represent the activity that is being done. For example, if I say, if I'm making dosas and if I call my dosa shop Benne Dosa or Butter Dosa, those
Indeed.
are what are
Yeah,
descriptive
yeah.
names. I am told those are the most risky.
Indeed,
So
and I think more useful, Manu, maybe to get your thoughts. But what we see is that both while registering a company name and also a brand name, the more descriptive that you make your name, the less likelihood of you emerging successful, because it's too generic a name, it's too descriptive, it's already available in the public domain. Chances are that someone or the other would have taken up the name altogether. I mean, you can always have cases where companies take a very calculated risk. I mean, I would say, for example, you would have been noticing the dispute between Indigo and Mahindra, right? Indigo goes by the code name 6E, and Mahindra for some batch of their EV vehicles also had 6E in the description. Now, clearly, that's a euphemism for a term. But the point is, I would assume that Mahindra's being the kind of organization that they are, they would have taken this as a calculated risk. And the way they are trying to now fight it out in the courts is to say that they are in a different category altogether, so they're not really competing with Indigo's services. But I'm sure you deal with this. You see this a lot more in courts, and the more descriptive or the more generic you make your brand name, the less likely it is to stand the rigor of courts.
descriptive terms are quite risky because everybody is going to do that.
Indeed, indeed, indeed.
I had I had one very serious question. For how many years do you think spouses should wait for the startup of their marriage to settle before beginning a startup journey?
What is it, Manu? Is it a 7-year itch that they call it? If that is the case, then 7 years it is. But no, I don't have a suggestion on that one.
Very well. The next set of questions that I had was, now let us assume that in this startup journey, a startup has somewhat stabilized. The next uh, thing that most startups would want to do is to raise funds. Oh, what do you think are the best steps to take to be able to raise funds for a startup if you are advising a startup?
Yeah, so I would say two things, right? One is, again, there are certain routine issues which companies and founders need to take into account. And then there are slightly more egregious issues, if they do exist, which you need to sort out. And what do I mean by this? there are usually invariably, right? Whenever you go for a fundraising, you'll always have some or the other issues. Where either the registers are not maintained, filings not done, licenses not obtained, lack of adequate documentation. Not ideal, all of these, but most, if not all of these, can be fixed. Either you need to make that filing post facto, you need to go through what is called as a compounding process with the RBI or the ROC or what have you. Um, but the more egregious ones, which is what I think people need to focus on, is things like having a very, very complicated cap table where you've got too many different types of investors with different sorts of shares. And that's the sort of cap table which investors are usually wary of, because it's quite difficult to set all of that right and to simplify it a few years down the line. Or if there are a web of, say, related party transactions where apart from this entity, the founder or founders have other entities which either supply goods or services or what have you to this, and it's a mesh of uh, intergroup transactions. Again, investors are quite wary of that. The third one I would say is that where there are too many family members who are involved. I mean, it's quite natural that when founders start up, they would tap into their family network to take care of certain aspects within the company, even though they may not have a central role. But before you go out and seek capital from external investors, it's good to clean up as much of this as possible. And I'm talking even about the routine non-compliances, right? Get a vendor diligence done, try and clean up as much as possible so that when you go and approach investors, you're going with a relatively clean slate rather than the investor having to pick up many of these things as part of the diligence, which leads to inevitable delays, yeah, inevitable heartburn. So it's important to clean up as much of this as possible before you go out and then seek funds.
Once one is able to seek funds, is there an optimal level to which you think do you think founders should take their shareholding to? Is there a cutoff below which they should never go? Or would you say it all depends on the way the business is running?
So clearly, it really depends on how the business is going and what you value it at, and how much you're willing to let go. But I would just say one thing on this, Manu, that founders need to be careful about diluting too much too early, because in some ways it is a bit of a long journey, right? Because before you can either be a potential target for a serious strategic acquirer, or even before you were to go public, there are several rounds of capital that one usually goes through. There is Series A, Series B. We've seen cases where it goes up to F and G before they go public. So at each stage, you're really diluting yourself more and more and more. So you should avoid the temptation, of course, to dilute too soon, too early. And on this, I would say that in many cases, founders do not pay as much attention to the anti-dilution clauses that inevitably form part of some of these investor agreements, where effectively the investor says that, look, you're raising money from me, assuming a valuation of X. Tomorrow, if the value of the company were to go down, effectively the investor says that my share in the company, or my value in the company, should not go down, which means that I should have a bigger chunk effectively of the reduced capital, and which can be achieved by having differential classes of shares and things like that. But even within this, there are various methods of doing anti-dilution. One is called a weighted average mechanism. The other one is called a full ratchet mechanism. I think it's important for founders to focus on some of this detail, um, in whether it's at the term sheet stage, or definitely at the shareholders agreement stage, so that you don't sign up to something which you're not really mentally prepared for. Because if that event were to happen, then you don't want to get diluted uh, to to uh, to a to a level that you didn't foresee. So at least you need to know what you are signing up to.
One thing I have seen play out in disputes, especially, at this stage is if the founder cede control of more than 50% of their shareholding, that is, the investors put together get 51%, then at any time the founders can be replaced. That is in terms of the role they play in the organization. I have seen disputes play out at that number. And what I have seen more often is invariably one founder will side with the investors and topple the balance. So the
Indeed,
founders
indeed,
put together sit at 51, the one founder switches sides. So
totally.
I have seen that happen, but I guess all of that is inevitable.
No, and also you raise a very important point that founders also need to think about the two roles that they play, right? One is as an executive or a KMP, if you like, a key managerial personnel of the organization, where you're in the role of a CEO, CF, COO, or a CTO, or what have you. The other is as a shareholder. And both these are important to distinguish from because while, say, the board of the company, if it were to have a majority of investor nominees, eventually can terminate the services of the founder as an employee of the company. But as far as the shareholding is concerned, that falls in a different
Remains in.
bucket. While there are interlinkages where they could have a call option to buy you out and things like that, but that's a different hat in some ways. So one needs to focus on both of these because it's not a given that the moment you're no longer an executive, you somehow magically cease to be a shareholder. Now, unless of course there are events which have occurred which mean that your shares could get bought out by the investors or for a nominal value, invariably we see that even if you were to fall foul of your obligations as an executive, you still have a key role to play as a shareholder
Holder.
in the company.
One other big issue that I see is many a times startups get funds from overseas. So what are the foreign exchange laws and foreign exchange law implications broadly that startups and founders need to be aware of?
Yeah, and on this, there is in fact a simple rule of thumb that we tell most of our clients, whether we are acting for the startups or for investors, that from a RBI perspective, because this whole foreign exchange regulations is driven by the RBI, when a foreign investor comes in, then whatever is the fair market value of the company, that serves as the floor price, which means that the foreign investor needs to invest in the company at a price which is equal to or more than the fair market value of the shares. However, when a foreign investor is exiting the company, the prevalent fair market value at that time, at the time of the exit, serves as the cap, which means that the foreign investor, when they're selling out to an Indian party, whether they're selling back to the company or they're selling back to the founders or whether they're selling to another a new Indian incoming investor, the price that the foreign investor gets cannot exceed the fair market value, which means that the value that they receive should be equal to or less than the fair market value. So the simple way to think about it is that from an RBI perspective, they want um, the foreign exchange reserves, if you like, of the country as a whole to be to be at an optimal level. So you don't want, from a monetary perspective, they don't want foreign exchange going out of the country to the extent possible. So which is why this FMV serves as an effective hedge against it. Now, typically what happens is the parties agree on a price, and because there is no normative process as to how you determine the fair market value, it's usually a range. It's not really a specific number. It's usually a range. And typically, the price that the parties have agreed would usually fall within that range. But if the company is not doing well at all, then the price that a foreign investor who's invested previously in the company can expect to get out of the company um, is limited by the fair market value of the company at that stage. The foreign investor cannot get anything more than the FMV. There are ways and means to get to structure around this, but really this is the rule of the thumb in some ways.
See, I have got two very contradictory messages. One says the conversation is extremely captivating, and right after that, there's a question which says, will lawyers really have a role to play in advising clients in this day and age of generative AI? So, how do you answer the second one?
Maybe we started with that, right, Manu? And that it's
Yeah.
probably a good way to wind down the conversation, unless there are more questions. I mean, I'm sure you do. We certainly use AI ourselves. So I know lawyers are averse to using technology, but I think the technology has caught up with us, if you like. So we as lawyers and law firms are also increasingly using technology because in some ways we are persuaded, if not nudged by our clients to start using AI to make ourselves more efficient. And we see the benefits of doing this, right? Where at least routine work, summarizing points, research which would have otherwise taken a few hours, takes probably only a few minutes. And even from your disputes perspective, preparing your chronology or list of dates can be simplified to a large extent, and there are certainly advantages in doing that. Um, where I would say people need to be a bit cautious is to, especially founders and startups, is to in some ways replace your lawyers entirely with uh, generative AI, whether it's ChatGPT or what have you. And there are several legal tools as well. While you can use them as sounding boards, you can use them to assist your thinking, to inform some of your decisions. But in some ways, you'd still need to go to a lawyer in order to make sense of all of it, because at the end of the day, a lawyer is still on the hook as far as the client is concerned to provide that advice. Whereas an AI, there's really no liability, so to say. You can't go back to the AI and say you got this wrong, whereas the position of law was different. And of course, there are umpteen instances, and the audience will be familiar with this, that there's also this hallucination amongst AIs where they tend to make up things. But even if they're not making up things, what they provide by way of research, it definitely needs to be double checked, if not triple checked, by somebody in flesh and blood.
What I have seen is, mm, especially one of the bigger ones, they get things wrong routinely. Not the larger, broader picture, but when
Indeed,
you start asking pinpointed questions, they get it wrong. And the easiest way to find that is two computers ask the same question, it gives two different answers.
indeed. I mean,
So,
it also depends on the kind of prompts that you give, but absolutely agree that there is no substitute, at least as yet, for the kind of overlapping thinking that individuals can do, and the sort of what you call as intuition, and which comes with experience. I don't think there's yet a substitute for that.
not yet, for sure.
Yeah,
It's one thing to pop a crocin if I'm feeling a little feverish, but to try that with anything more serious could
indeed,
could turn out to be a disaster. And I think it's just the same. The one or
indeed.
two last set of questions: how does a founder or a startup plan for exit?
Yeah, I think we touched upon this briefly, Manu. There are broadly, what are the sort of exit that you're talking about, right? We spoke about
Mhm.
sale, a sale to a strategic buyer who wants to just buy the business or buy the company, or you can have a public listing of the company shares. So these are the two primary ways. But even beyond this, from an investor's perspective, it's also possible that the company itself, if it is flush with funds and if the founder wants to, in some ways, take back control of the company. And we've seen several instances of these, right? Where, for example, Dell, which used to be a public listed company, Michael Dell bought back the shares, and I'm not sure now whether it is listed or not listed, but it usually happens that if the company is flush with funds, you can in fact buy back all the external investors, and then the founder sort of goes back to square one in some ways, where you're in full control of the entity. There are also mechanisms like put and call options, where if an even if a founder is not inclined to sell out, the investors can effectively drag the founders in order to sell to a third party. But these are more adjunct to a strategic or a third party sale rather than being an exit itself. Um, the other thing, much like anti-dilution, uh, one of the other mechanisms which founders will need to focus on is this concept called liquidation preference. So when things are going well, when everyone is in the money, so to say, where they are making more than what they have put in and several times over, uh, there's usually no issue. But if there were to be a liquidation type of event, and by liquidation I mean this loosely, it's not just in the context of say a winding up or a dissolution of the company of the kind that you and I know about. But even if there were to be certain kinds of corporate restructuring and things like that, there are invariably provisions in investors' agreements where the investors could be entitled to a preferential return, where they need to get the return first before the founders and the other shareholders get the return. And there are several variations of how this liquidation preference could look like. And it's important for founders to pay attention to some of these mechanisms so that you don't end up losing out too much in case things don't go well.
Now, I can you tell our viewers five things that they just absolutely should not miss? I want the don'ts, not the do's.
Okay, I would say first one is don't think of legal and contractual compliance as an optional. In some ways, it's not important only for the from the perspective of the investors, right? Right from the get-go, when you start out a company, have legal and contractual compliance as one of your uh, core mechanisms, if you like, where you set in place systems, processes which ensures that you effectively comply both with the law and with your contracts. That's one. Um, Number two, don't ignore legalese, if you like, in term sheets and investor documentation, because that could prove to be counterproductive, where you're not sure about what you have signed up to, and invariably it comes back to bite you when things don't go well. Third one, like we discussed, don't skip having a founder's agreement, regardless of whether you're having it, whether you're forming a startup with your friends, relatives, what have you. In fact, I would say if you're doing it with relatives and friends, probably even more important that you have a agreement in place. Number four, I would say avoid having too many related party transactions and side hustles. To the extent it's important for your business, and as long as there is adequate disclosure made to the board and the investors, it's fine. But unless you're an Elon Musk, it's unlikely that you're going to get uh, paid $1 trillion, was it? While you have two or three businesses on the side. Um, and the last one, I would say again, don't rely only on chat GPT and generative AI. Learn from it, of course, use it to form some sort of a view, but don't let that replace professional advice.
So, just to do a quick recap of what we discussed, what's the best method to do a startup? I think broadly, Yashaswi's advice was a private limited company would be the best vehicle, but for professional services, perhaps a limited liability partnership could also be an equally effective way. And should a founder or should a startup register itself as a startup? The answer appears to be overwhelmingly yes. It's easy, it's not expensive, and it comes with a bouquet of benefits. The third big point that Yashasvi made was when a startup is going to take its first fledgling steps, to the extent one can, please document the relationship amongst amongst the founders, especially and more so if they are friends relatives, because invariably disputes spring from understandings that have not been clearly communicated to one another. 4. ESOPs are an important part of a startup's journey. It is always helpful to have an ESOP pool. A founder ideally should have an ESOP pool so that the founder does not get diluted. 5. When doing ESOPs, the startup as well as the founders must be wary or must be concerned about tax implications also. 5. Once a startup is in place and fundraising begins, the best way to approach fundraising is perhaps to clean up one's act. Invariably, there'll be some non compliances. Some agreements may be found wanting. It makes sense to reach out to advisors, get one's documentation in place, because while investments are made on the basis of business, the quantum of investment, the manner in which investment is made will also depend on the nature of documentation. Lastly, yes, getting foreign funding is not as complicated as it was earlier, but there are certain norms that RBI has. The foreign exchange regulations have to be kept in mind when determining what should be the structure or method of getting funding. Broadly, these were Yashaswi's points. Yashaswi, thank you so much for being there. For our viewers and listeners, all of you know where to reach Yashaswi. He's a click of a mouse away on LinkedIn. So am I. Although I hope and wish for everybody that you have the need for Yashasvi rather than me. But if that inevitable day comes when there are disputes, I'm always there. But I don't wish that to anybody. AEIF will continue coming up with more such episodes in the future. Once again, Yashasvi, thank you so much.
Thank you, Manu. It's been a great conversation.